You're listening to Legal Sounds, practical advice for SMEs, the podcast from Davis Blank Furness.
Hi, my name's Andy McNish and welcome to Legal Sounds by Davis Blank Furness, a legal podcast for small and medium businesses. Today I'm joined by my partners Lauren and Shiva, and Shiva is the head of our employment department, and we're going to discuss sexual harassment and issues around sexual relations at work. With particular reference to new legislation that's just come in, and hopefully in time for a Christmas party or two. So without further ado, I just ask Lauren and Shiva to introduce themselves. Thanks.
Hi, my name's Lauren. I'm a co-host alongside Andy, work in the corporate commercial team, but I often work alongside Shiva, especially when it comes to all matters TUPE. Shiva, if you'd like to introduce yourself.
Hi everyone, I'm Shiva Shadi, Head of the Employment Department at Davis Blank Furness. I have been there for many years and I'm older than the furniture, and I'm very pleased to be here to be talking to you all about sexual harassment.
Could you tell us, Shiva, what is sexual harassment then, in broad terms under the law?
So it's defined under the Equality Act, and it's basically defined as unwanted conduct of a sexual nature which has the purpose or effect of violating a worker's dignity or creating an intimidating, hostile, degrading, humiliating or offensive environment for that particular worker. So you can imagine in any workforce there will be a range of attitudes about what conduct is considered offensive or humiliating, intimidating, etc. And what one worker or the majority of your workers may consider to be completely harmless, a bit of fun, a bit of banter, another may find entirely unacceptable. So it's all about the individual and how they are made to feel, and if they feel humiliated, that's sufficient to meet the definition under the Act.
In terms of sexual harassment then, Shiva, what are kind of common examples that you come across that you'd maybe expect an employer to encounter?
Sexual comments or jokes, mostly disguised in banter, suggestive looks, staring, leering, displaying sexually graphic pictures, so pornography on laptops or PCs, propositions of a sexual nature, making promises in return for sexual favours, all that kind of stuff. It could just be anything. It could be graphics, it could be graffiti, anything verbally written or visual would amount to sexual harassment.
Saying actually this is topical because this very morning Greg Wallace has been accused by 13 different women of sexually inappropriate jokes, and has had to step down from his role as in MasterChef. So it is certainly a topical matter.
Yeah. So
you've obviously mentioned about the new legislation itself. So what is it? What's
it's a new duty that employers have to take reasonable steps to prevent sexual harassment taking place. So they can no longer just have a policy in their handbook. They now have to take positive steps to protect their employees on a daily basis to avoid sexual harassment.
So it makes it much easier, effectively. It puts the onus of proof, if you like, on the employer, the burden of proof. So it makes it easier for someone to sue the firm if they think there's been sexual harassment to them.
Yeah, certainly employers will now have a higher threshold to meet in terms of steps they take. So the onus is squarely on the employers to address issues and prevent them occurring. So they can't wait till it happens and then take steps. They have to take steps immediately as a new employee walks in, have everything in place so that that individual isn't placed at risk.
And in terms of this sort of new duty, when did it kind of come into effect?
26th of October 2024, so literally just a month ago. So it's very new, and employers who haven't sort of started to address this new legislation should do so as soon as possible, because the duty is here and the onus is on them, and they will be held vicariously liable if they don't take steps. They could take a certain number of steps, but still it might not be enough. So it's really important that they carry out all the steps that we're going to discuss today.
So obviously policies, just having a policy in your handbook that no one ever looks at isn't enough. So what is enough, I suppose, is the next obvious question.
So policies are great, but you've got to do more than just have your policies. They have to be communicated to the employees. They need to be fully aware of. They need to be updated. They need to be reviewed on a constant basis. They literally have to be a living organ within the organisation. So yes, just having a policy is not enough, but there is a lot more that needs to be put in place. So training is the key. Training. So your training has to be focused. There has to be an explanation of what harassment is. You have to be categoric about what the business will do if there is sexual harassment. You will have to set out acceptable workplace behaviour, cover the grey area of banter because that's critical. They should set out what your employees should do if they experience harassment. The training should also set out what individuals do if they see harassment rather than just experience it. And cover steps that they should take if harassment is reported directly to them. So sometimes individuals, colleagues talk to their cohort within their hierarchy about something that's happened. What should those colleagues do in those circumstances? Or it might be reported to somebody more senior. Again, what should those senior members of staff do? They all need to be trained to know what steps to take to protect the employees, but also the company or the organisation.
And in terms of the employer itself then, if a complaint is brought, what would you expect them to do in that situation?
You go straight back to your policies and follow them. Act swiftly, carry out an investigation. Don't just assume that the allegation is correct, because the number of times where allegations have been raised and we think, oh dear, that sounds really bad. And then when you actually look at the evidence, you find that the facts was something entirely different. So don't make assumptions, carry out a proper investigation, do it as quickly as you possibly can, and take steps where necessary. If you need to dismiss an individual, dismiss them. If you need to give them a final written warning and send them on a training program to be more aware of their actions and conduct, then do that. But it's to literally go back and rely on your policies that you already have in place that will guide you through the process.
And in terms of policies, what kind of policies would you recommend that an employer has? So
you definitely need a harassment and bullying policy with a specific section on sexual harassment. You will need equal opportunities policy, and supporting that you'll need a disciplinary policy that specifically states that you will dismiss if there is sexual harassment and list it as gross misconduct. You also need a grievance procedure that again deals with this, and it will also be helpful to have sexual harassment and harassment covered in a communications policy that you have, your email, internet communications policy, clearly indicating to employees what is acceptable and what isn't in terms of the manner in which they communicate with their colleagues or clients or third parties.
What seems a bit difficult about the way you've described sexual harassment as an issue that can found a claim is that it appears to be almost entirely dependent upon not necessarily what's said, but upon the way the person hearing it then is offended or not by it.
Yeah.
So if someone says I'm offended by something, that's almost a proof of sexual harassment, isn't it? I mean, unless they're lying about what was said, how can you defend yourself against a claim if that's happening in the workplace?
You have to look at the bigger context. That's one thing. As part of your investigation, a comment was made, but in what scenario was it said? And also you have to look at how that individual participated in that conversation. So there'll be cases, and there have been cases, where individuals have been subjected to sexual harassment in terms of wording that's been used in a conversation or as part of banter, but when it's been looked at, it's been found that that individual made similar comments in that conversation, or the conversation the day before, or the month before, and therefore it's an environment where they contributed to that sort of sexual harassment environment. And in those circumstances, a tribunal could hold that actually that didn't amount to offensive behaviour and that person wasn't sexually harassed. But that tends to be the case more in other areas of harassment. Sexual harassment can be quite specific, and it is difficult, unless the facts show otherwise, not to find that harassment has taken place. But you also have to look at who's being targeted. Sometimes there are scenarios where an individual is literally targeting a colleague in the manner in which they're sexually harassing them. So that can be different. And it could be that somebody makes a comment, but they've been provoked to make that comment. So that's why you need to look at it in the context. It's just part of carrying out a thorough investigation, speaking to witnesses if there were witnesses, and speaking to, obviously, the accused as well as the accuser. And then making a difficult decision. And sometimes they are difficult decisions because it's one person's word against the other, but HR managers and directors and whoever's in charge of dealing with the investigation does have to come out with a decision. And as long as their decision is reasoned and based on the investigation that's been carried out, it should be okay.
So given it is really sort of a case-by-case basis that it's kind of worked out, how would an employer really be able to monitor how well they are at complying with this new obligation, and how can they sort of reflect on their own success or failure in this regards?
Well, it's all part of keeping a constant review. So if you have a policy and an incident occurs and your policy didn't cover the incident, go back and update your policy, review that. Once an incident has taken place, an investigation taken place, review how that was dealt with. Was it dealt with promptly? Did you manage to resolve the issue in the workplace? Do we need more training? So there are ways that employers can assess it, and also the number of sexual harassment claims that are being raised. So just because they're not being raised doesn't mean it's not happening. But if you have got in place systems whereby individuals can report, and reporting should not just be having to make a written statement. Some people want to do it anonymously because they don't want to raise a big issue. Other people want somebody to speak to. Other people want their hand held through it. So it's about providing the best opportunities for individuals to raise these issues. And then once you've dealt with them, looking back and reassessing how the company dealt with it. Is there a way of improving the situation or the processes that were in place, and putting in place more training, especially for managers, because they're the ones that normally are sort of approached with these issues, to ensure that things are progressing and improving.
So with Christmas party time coming up, and obviously throughout the year, there'll be social events that are happening after work, but perhaps sponsored by work or involving work colleagues. To what extent does an employer have responsibility for those, and what are sort of good ideas that might be put in place to try to minimise or try to comply with your duties?
Well, Christmas parties, office Christmas parties do fall within work, and therefore employers do have some responsibility. So the best way forward that I advise my clients is send out a very positive email now, just before the season starts at 1st of December, and inform them we've had a great year. We want everybody to go out and celebrate and enjoy themselves. But whilst enjoying yourselves, please be mindful of your colleagues. If any issues arise, have individuals that they can go to. So in the email, say, if you're feeling uncomfortable at any point during the evening, or if you've got any concerns, please approach one of the managers, directors, whoever it might be. Point them to the fact that they may be going home later at night, and therefore have they made arrangements to get home? Does anybody have any issues about getting home? And just remind them that whilst everybody is going to be happy and drinking, that they should be mindful that they are conscious by the end of the night. A lot of employers are now limiting the amount of alcohol they provide to their employees based on this new legislation. So that's another consideration. But limiting drinks, you can do that to a certain extent. I can imagine most employees will turn up with a hip flask if they know they're going to be rationed on the alcohol front. But yeah, just be sensible. Just remind them that they should look after their colleagues and keep an eye out. And if there's an issue, they should come to you. And you've pretty much covered all the bases that you can.
I'm assuming the person that you point them in the direction of is the designated driver, person who's sober and...
Yeah, most organisations have somebody who's teetotal or doesn't drink as much. Or, some companies have 2 or 3 or 4 events that the staff attend during the festive period or, throughout the year. So just... take names out of a hat and say, on this occasion, stay sober so that if any issues arise, you're alert to them and you can deal with them. So, divvy up the responsibility between your management team.
And in terms of the management team, is there any kind of warning signs, anything that they should really need to be sort of alert to and alive to the fact that, these are the things that...
Yeah, so the guidance from the EHRC stipulates that managers should actually get far more training than the employees in the workplace because they are going to have to deal with it and they have to also set out an example. So they really have to be alert to changes in staff behaviour. So, if an individual's being quieter than they usually are, if they're making more mistakes than they would otherwise make, if they become withdrawn, if they say they don't want to work with a specific colleague, whilst you may think, oh, they're being awkward and difficult, it may actually be that something has occurred with that individual which makes them uncomfortable and they don't want to work with that person. If they're not being as productive, all these things are signs that something's up, and it could be something that's going on at home that you're not aware of. But then again, it could be some sort of harassment or bullying or sexual harassment in the workplace. So there's no reason why a manager can't just address that and say, are you okay? I've just been noticing that you've been a bit withdrawn and a bit quieter. Normally, you're life of the party. Is everything okay? Is there anything we can help with? Do come to us if there is anything at all that you'd like to share. And if not now, at another time when you're ready to do so. And you'll often find that the employee, as long as they feel with the person that's asking those questions or querying that, will give you some information about why they've been behaving differently.
On Christmas parties and similar social events, is there any benefit in having a hard stop and saying after 10:30 or 11 o'clock the event ends, and as far as we're concerned, and you're on your own? Is that sensible, or does it have any? Is it useful?
I think you can certainly do that. So what you will say is that doesn't necessarily have to be a Christmas party. So it could be a training event with drinks and food that's provided afterwards. What you could say is that the working event or the company event will end at this point, and make it very clear that it's ending at that point. If you are going on to other social events or gatherings, please be careful and make sure you've made arrangements to be able to get home if you're going home later. So you've made it clear that when it's ending, but in reality, if all your employees then go to the bar or the pub or the club down the road and something occurs and one of those employees raises a complaint, it's very difficult for you not to address it and say, well, not our problem, you all went out afterwards, because you still have to deal with the dynamic of those two employees in the workplace, where one of them could be very aggrieved, on whatever basis, whereas the other individual may be completely oblivious to what's going on and will carry on regardless. So it's very difficult not to address it, even though you've sort of put a hard, fast stop on when the work event is ending. But certainly you can do that because it gives you some leeway if you need it.
I know you've obviously mentioned about colleagues there, but what about if there's third parties involved? So what if there's a contractor that comes into the office, or if it's an external event and there's obviously external people then involved? What's the employer's kind of obligation then?
So initially, third party sexual harassment was included in this act, but when it went through the House of Lords, they've removed it. So at the moment, employees can only bring claims in the employment tribunal if it involves a colleague, so a co-worker, another employee of the company. They can't bring claims against the employer in respect of a third party. However, under the HRC, they can raise a complaint to them and they will investigate. They will make the employer make changes and put in a plan, and it can go all the way up to the courts.
I suppose there might be two different sorts of third party if you think about it. If it's an event that is a firm event and they've invited the third party to it, then that's one thing. I suppose if you're just going to one of these shared events where there's 20 different firms all at Old Trafford or somewhere, and somebody from another table staggers across and makes an inappropriate comment to one of your staff, then that's much harder to be seen as the employer's responsibility.
At the moment, under legislation, it's not differentiated. However, Labour are bringing in third-party harassment and liability for employers. So employers should actually take all that into account and take steps now, whilst they're taking steps in respect of sexual harassment to do with employees, to cover third-party harassment as well. So it's a matter of putting signs where you think there are concerns in respect of, you've heard it on telephone calls where you phone centres and they say, we do not accept any abuse of our staff. So there would be an extra of saying no sexual abuse of our class, no sexual harassment. So companies you will see that more and more now going forward, given what Labour have introduced. And one of the big steps that employers, or a reasonable step that employers have to take, is to carry out a risk assessment. So they really have to look at where the hot spots are within their business or within their organisation that could raise issues of sexual harassment and target those areas. So the first thing any employer should do is carry out a risk assessment, decide where the areas of concern are, decide what steps they need to take to prevent those areas occurring or those situations occurring, and then decide which of those steps are reasonable. And, if you're a big organisation, then you'd be expected to do a lot more. A smaller organisation, it might be cost prohibitive, and that will be taken into account. So a risk assessment is the biggest key when you're starting out on trying to protect your employees and also obviously the company.
So I know obviously you've mentioned about risk assessments, but what actually needs to be considered and sort of included within the risk assessment itself?
So have a look at power imbalances. Have you got a hierarchy made mainly of males, for example? Can be females as well. Is that an area of risk? Job insecurity. So the guidance sets out, use of 0-hour contractors, agency staff and other individuals who don't have employment security. Out of hours working. Do you have an individual that stays late and works in the office alone, or a few of them that stay late and work alone? Presence of alcohol, obviously, as we've discussed. Lack of diversity in the workplace, especially at senior level. So, like I said, are they all males or are they females, or have you got a mixture? If you've got lots of female, for example, senior management, and you've got all men at a different level in the hierarchy, does that, cause a problem? Travel to different work relations, if individuals are working at home. Attendance at events outside. So, if they're going to conferences, if they're going to exhibitions, are there any risks? Do they need special training? Social media contact between workers. So WhatsApp is a great one where people feel like can say whatever they want at any given time. Sometimes they actually forget who's on the group and, make some offensive comments. it was just like Facebook as well. People forget who they're friends with, or that their colleagues are friends on their Facebook group page. Just workforce demographics, all that kind of stuff. So you look at all these risks and you go, okay, so this is the risk. What can we do with that? So if you've got people working late, provide them with a telephone number they can contact if an issue arises. So if they're working alone, again, provide them with an alarm and telephone numbers. You can see steps that you can take that are perfectly reasonable and not that costly. So there are lots of steps you can take.
Just slightly more generally, that this is obviously a special. This new legislation puts a specific onus, a specific burden on the employer to take steps to prevent sexual harassment. What about other discriminatory, anti-discriminatory obligations? Like, why isn't there, for example, the same sort of obligation in relation to all sorts of, racial discrimination or other sorts of harassment? Why is sexual harassment been picked out as a trial run? Is this gradually expected to come across the board to shift towards employers?
I think it's all to do with the Me Too movement that kicked off a few years ago. It's a hot topic. It's at the forefront of the media. There's been lots of complaints. We've got the whole Al Fayed matter, and there's been lots of matters like that. So it's something that's been a hot potato that's needed to be dealt with. And, you have policies saying we have zero tolerance on harassment or sexual harassment, but it still occurs. So there was a feeling that steps needed to be taken to put the onus on employers to train their staff, to inform their staff, and to provide a vehicle whereby these matters could be raised and sort of prevented from occurring again, I guess. But the government will bring, I'm sure, a duty on employers to prevent other harassment. I'm sure the Labour government it'll be certainly one of their key points that they will raise. Whether it will end up in legislation, we'll have to wait and see. But certainly it's a topic that's being addressed.
I suppose just broadening it out, sexual relationships between staff or allegations of unwanted sexual speech or conduct are often very difficult or quite difficult for employers to deal with. They can cause a lot of issues within the workplace. And of course, you've been dealing with these things for more than 25 years, so you must have seen just about everything in practice. What general principles, not necessarily the specific legal obligations under this new legislation, but what general common sense principles or steps would you think the employers should bear in mind to try to sensibly navigate what can be a bit of a minefield?
In terms of relationships within?
Yes. Well, what sort of general issues are there about sexual relations or allegations of unwanted speech or conduct?
Well, with sexual relations, I think what you have to realise is you're dealing with adults in most cases in the workplace, and there is an option always to do nothing. That is always an option. So individuals have the right to a private life, and that includes, going out with colleagues, having a relationship with colleagues. As long as they're consenting adults, it's not an issue.
So by consenting adults, do you mean literally over the age of consent, 16, or is there a special consideration of people who are 16, 17 in the workplace?
I think you'd have to look at the specific facts, but if it's two 17-year-olds going out, that's not going to be an issue. If you've got a 30-year-old going out with a 17-year-old, that might be slightly more uncomfortable. And you may want to take steps in respect of that, but you have to be careful how you do that. But in terms of individuals having relationships with their colleagues, you have to take it that from the outset, they're consenting adults, and that's what they're choosing to do. And if they're having an affair, again, employers aren't the morality police. Step in if it's affecting their work. So, if they're sending emails to each other instead of working all day, you have a reason to raise it. If they're standing in the stairwell and chatting all afternoon, then obviously you've got an issue and you have to address it. But in terms of just individuals who happen to be in the same building having a relationship, I don't really think you can take or should take steps. Inevitably, however, these relationships do break down. and then issues do arise, especially if they're in the same team or one manages the other. That can obviously cause complex issues, and you just have to navigate those situations as best as you can, confidentially, swiftly, and sensitively. And, there's no other choice, really. You just have to wait and see. If you have got serious concerns, then go and, you've got, say, a manager and going out with somebody who's far more junior than them, you may want to have a chat with the manager and say, just checking you're aware of this, this situation. Is everything okay? Be careful.
Have a chat to the manager or to the manager, the younger one.
The manager, because the younger one could be under the influence of the manager, so you don't necessarily want to raise it with the younger individual, other than you may want to go to them and say, just checking everything's okay.
Yes,
you're hanging around with management a lot. Everything okay? Any issues, come to us. You might want to do that, but it's an uncomfortable conversation to have, and it could actually raise more issues than it solves, because that person could then be embarrassed and say, I can't possibly carry on working here. Everybody knows about this. Nobody's going to take me seriously. And you could end up in a constructive dismissal claim situation. So you just got to be very careful, and I would only approach it if you feel that it's necessary. If you've got two people that are critical to your business and your business hangs on, their capabilities and their duties and their skill set, and they start dating, you might get a bit more hotter on the colour and be a bit more concerned. I can see scenarios where that situation could arise, but my advice is leave it well alone if you can. Leave them to it. If issues arise, then address.
It certainly sounds quite precarious, some of the situations that employees can find themselves in. I suppose, what would be your kind of top tips, really, now that this obligation has been placed on the employers? What do you recommend?
I think training is the key, as I said earlier. Train your employees, let them know what's acceptable and what isn't. Train your managers to be able to deal with them, because a lot of times there was a case against Asda where a male employee had been kicked twice, and he raised the complaint saying, I've been kicked twice. And he was just ignored by the managers, saying, ridiculous, man up.
Kicked on the bottom in some sexual way, or just generally kicked?
Just kicked twice.
Why is that
in the
sexual
bottom.
Harassment? Oh, the bottom.
Well, it's not necessarily sexual harassment,
right.
but I will expand in a second. So they didn't deal with it. HR didn't deal with it, and he brought a claim in the employment tribunal, and he was awarded £29,000 because it was sex discrimination, because they said had a female complained that she had been kicked by a male, they would have investigated it. But because it was a male, they were asking him to man up rather than actually investigating it. So sex discrimination. So it's a scenario where the management completely missed the point and didn't deal with it appropriately. So that's why it's important. If you train your managers, train your employees, let them know what's acceptable and what isn't, hopefully they will all behave and fall in line.
Thank you very much. I hope you've enjoyed listening to this podcast. Thank you especially to Shiva for coming in and giving us her wit and wisdom for the last 35 minutes or so. If you do have any questions about the matters discussed in this podcast or any other legal issues, please don't hesitate to get in touch with us. Shiva especially is around to help with all your Christmas party fallings out, whether this month or in January when the dust is about to settle. Thank you very much. I hope you enjoyed listening to Legal Sounds from Davis Blank Furness.